We are live. I'm going to wait till some more people join us to get started. Thank you, Mr. Polite, for joining. This phone. Oh, Lord. All right, we're live on Instagram. Hi, Reggie. You guys can send messages on the chat. The camera's in front of me, but I'm going to be looking at the computer because it's down here. Alrighty. Hello, Timo. I could see you. I don't think anyone else can see you. Just sharing this on Instagram. Please share it with your friends. This is an opportunity to answer any of all of your trademark related questions. Again, I want you to pick my brain. So if you have any questions about branding, please let me know. We have another Terrence in the room. Hi, Terrence, with Ripe Brand Clothing. Okay, let's get started. Hello, everyone. My name is Shawnette Stokes. I am the managing attorney at Stokes Law Group. We specialize in estate planning, probate, personal injury, and trademark law. We also have entrepreneurs that need business formation, contract review, and litigation. So we cover a broad range of services for our entrepreneurs. And today we're here to talk about trademark law. I'm here. There's no structure to this video, this stream. I'm only going to be on for about 30 minutes. I just want to give you all an opportunity to answer any questions that you have related to trademark. I know there's a lot of people that would like to schedule a call with my office, but they cannot afford a full consultation. So I'm giving the opportunity to have the entire audience ask me any question related to trademarks that they did not think that they had. And you may have follow-up questions when other people ask questions. So do not hesitate to shoot me a message on this platform so that I can answer them. And I also posted questions or opportunity for someone to ask questions on my Instagram stories. So if you have questions, I'm going to be toggling in between StreamYard and Instagram Live. All righty. I had a first question about branding and prenuptial agreements. Individuals really want to know, how can I start my business and then have a relationship, a marriage, and protect my brand if something goes wrong within my marriage. I always tell my clients, you need to have a prenuptial agreement. It needs to outline everything as it relates to your personal life and your business. In that prenup, you need to make sure that you state that you retain all rights and ownership and interest to your company. Now, if you start your business while you're married and the relationship dissolves, your partner is entitled to a portion of the profits from that company. So bear in mind, if you are a married individual and your relationship dissolves, your partner is entitled to a share of the company. All righty. Another question I get often is, what's the difference between trademarks and copyrights? The difference between trademarks is it's your brand identity. So think about what you put out to your clients. It could be your brand name, it could be your slogan. Colors are protected under trademark law. So the Tiffany blue color, that is protected. The red bottom on the Louboutin shoe, that's also protected. You can also protect jingles. So songs, the NBC chimes are protected. The pink insulation in the walls is protectable intellectual property. Now, there is a slight overlap when it comes to copyrights and trademarks. So you can protect your logo, we know that, but you can also protect your logo under copyright law. You can also protect all of your content. So we all, as entrepreneurs, we are content creators, right? So everything that you put out to the public can be protected. So what I mean by that is, if you are creating YouTube content, educational curriculum, if you created a course, that can be protected. The NBC chimes, as I said, is protected over in the trademark realm, and it can also be protected in copyrights because it is music and it's also your brand identity. Oh, Terrence with Right Brand Clothing said, "We trademark because of you." Thank you so much. I try to sit on my platform and explain to you all the importance of registering your mark, because when you have a trademark, you can stop other people from using your brand. And if you fail to register your brand at any point, you run the risk of someone else registering that brand. We have a question. For businesses that don't have the revenue yet to support full legal support, what would you recommend as a top priority for brand protection? I recommend you aligning with an attorney that supports your budget, because I can't tell you to do it yourself. I never recommend anyone to file their trademark on their own. If you ever get sued, right, I highly doubt that you would go to court by yourself. Actually, in Florida courts, if you are a business and you get sued, you need to hire an attorney because that is a legal requirement. With the USPTO, it is not a legal requirement to file before the USPTO for trademark registration, but it is synonymous to you going to court on your own. You do not want to navigate those waters alone. So I would highly recommend that you prioritize getting your trademark filed and align with someone that fits your budget. Also, there are attorneys. My law firm offers payment plans, and there are other attorneys that offer payment plans as well. We have a 3-2-1 payment plan structure. So your initial deposit is due at the before the initial consultation, which is $300. Then we require half of the balance 14 days after that initial $300. And then the final balance is due 30 days after the initial deposit. So as I said, align with an attorney that fits in your budget. Okay. Any more questions? That was a really great question, Gigi. Thank you. Any more questions? So I also receive questions about, what can I do after I've gotten my registration? If you see your business expanding, one thing that you can do is actually franchise the company. If you don't have your brand protected prior to your decision to franchise, then it's as though you are allowing someone to drive in a stolen car. You cannot give someone the access to using your brand name without knowing that you are fully covered when it comes to brand protection. Because if you don't have your brand protected and you franchise your company, then you run the risk of not only getting sued, but then your franchisee could potentially get sued as well. So you are creating more risk than opportunity for anyone coming in and sharing an interest in your business. I'm going to give more time for questions. And that was the last question for businesses that don't have the revenue yet. So as I said, you may have to budget for it and align yourself with an attorney that can fit within your budget. And can you guys hear me okay? I'm seeing that people are having a tough time accessing the link. Hello, James. How are you? Thank you, Latoya, for joining me. Come on now. Any more questions? Thank you. Okay, so the audio sounds good on YouTube. Perfect. Awesome, awesome. How does the visuals look? I tried hard to make it look crisp for you guys. No janky video over here. Any more questions? So if you have questions and you want me to bring you to the stage, let me know. That would require your video to show up, guys. I see some people talking, but I can't hear them. So a lot of people want to know the timeline when it comes to trademark registration. With the USPTO, they are backed up. During COVID, there was a lot of trademark applications that were filed. I think there was an influx due to the great resignation, I suppose. Everyone was quitting or getting laid off, right? So everyone became entrepreneurs. And a lot of people started seeing the value of registering your trademark. And because of that, the USPTO had to hire additional attorneys to handle the influx of applications. It used to be 9 months for processing the entire trademark application. Now it's about 14 months. So when it comes to making the decision to protect your brand, you want to make sure that you file it immediately. Or even if you have the decision that you want to launch a brand name, but you haven't launched the service or good, file it still. You can file your application as an intent to use application. There's a lot of celebrities that do that. I spoke about this yesterday. You have Kylie Jenner. She does this every time she makes the decision on launching a new business. Before she even puts it out to the public, she files a trademark registration, because if you file that trademark registration before any competing mark, someone else in a different state, then the USPTO is going to review your application first. So we need to start acting like celebrities and rich folks. If you want the money, you got to make sure that you protect your business. And the only way that you can do that is if you follow the same blueprint as the rich people do, right? All right. You guys, I see that you all have joined on Instagram as well. So if you have questions, don't hesitate to ask them. And I'm toggling back and forth in between Instagram and StreamYard so I can see comments on both, and the comments on YouTube come to me directly through StreamYard. Terrence with Right Brand, I would love to join you on live. Just let me know when you want me to. I am open to doing partnerships on live video. All right, we have another question. Marshana Stokes. That last name sounds familiar. That's my little sister. Do you have any suggestions for social media influencers to create sayings or trends or dances? Oh my God, that's a great question. So, when we're talking about going viral, we don't anticipate that happening, right? We could talk about Jules, the young lady on TikTok that said very demure. She didn't anticipate going viral, but I do believe that she had been using that before. She went viral, everyone loved it, everyone's using it. When you see that moment that you see that your brand is taking off, you want to protect it. You want to contact an attorney to protect it, because at the phase that she was in, as soon as it went viral, her just saying very demure is not enough. Just like the young lady that said her eyebrows were on fleek, right? I'll never forget that. If you do not connect that phrase or that saying with a good or service, then it's not protectable. So you want to make sure that as soon as you have something that the broader community enjoys, you get ahead of it and make sure that you protect it and connect it to a good or service. You can create a clothing line. So you can call it the very cutesy, very demure clothing line. That is attaching it to a good or service. So, as I said, you can't anticipate going viral, but if you know that there's a phrase that you like to say and you say it frequently amongst your friends, go ahead and protect it, because we live in the age of the internet. And we've seen with the very demure brand that someone else has filed a registration for that brand, right? What may happen with that person that filed that brand before Jules is they could get their application rejected before the USPTO, because her attorneys can come in and say, hey, this person committed fraud upon the USPTO. When you file fraudulent applications before the USPTO, they will penalize you and actually stop you from even filing any additional applications, because now you're playing with the federal government and they don't play about that. So make sure when you are filing your applications, and we are even aligning with an attorney to have them file the application, tell the truth, because you never want to have someone file suit against you in federal court and they say, hey, this person lied on their trademark application. When you lie on your trademark application, that is considered fraud upon the USPTO. So one thing that I've seen is people lying on their trademark application by saying, I started using this brand on January 1st, but they actually started using it in May. So you have to be very specific in the information that you're providing to your attorney, because we're submitting that to the federal government. And that is, your application could very well be used in litigation. and it could be a defense. So if you filed suit against someone for trademark infringement, one of their defenses could be, hey, this person didn't even start using their brand until May, and they filed the application and said they started using it in January. Their defense could be, hey, this person committed fraud upon the USPTO, so they shouldn't even have a valid trademark anyway. And that would end the case. So you do not want to lie to the USPTO, and then all of the hard work that you've done in protecting that brand has gone to waste because your trademark is invalidated. So that's a really good question. And going back to the trends and dances, the Carlton dance was, I believe, copyrighted. So you can copyright choreography. As long as you write down the technical steps, you can submit that to the Copyright Office for protection. With copyrights, you cannot sue someone for copyright infringement until you have a valid copyright. So bear in mind, if you are creating content, if we are posting videos, we're posting blogs, we are creating curriculum, ebooks, and putting it out to the public, and someone steals it, then you can't sue them until you have a valid copyright. Your copyright registration is your golden ticket to court. So you are not entitled to damages until you've shown that you have the legitimate ownership of that content. So I know that we are in the age of creating content. Content creation is our billboards. From back in the day, we used to drive down the street and see everybody's billboard. Now we see advertisements through social media. You should leverage your content for money. So a lot of influencers, they do product reviews in exchange for compensation. And they are licensing their video content to this company. And most often they're giving them a exclusive license for probably just a small fee. And when you give someone an exclusive license to use your content, guess what? You can no longer use it because you're telling them that I am giving you 100% right to use this content and no one else can use it. That includes yourself, right? So when we're talking about creating content and leveraging it for monetary gain, you want to make sure that you have a good understanding of how you should protect it. And of course, I say always hire an attorney, consult with one, and create a brand strategy on how to leverage the content you create because you can make money. We all know that content is king. We also know that the marketing strategy is now in the hands of the consumers with UCG and influencers. You don't really see models online on video ads. You see real life creators coming online, showing content and giving reviews on products. And these corporations are now using that in their ads. And now they're making tons of money. Imagine how much money they've made on your one video. So you have to make sure that you leverage that content. And the only way that you can do that is actually doing a little bit better with negotiation. All right, I have another question. Can we create an NDA without an attorney? I don't recommend you doing anything without an attorney because I'm always the person that thinks of the worst case scenario. And when we're drafting contracts and we're engaging in transactions with friends, even future employees, we have rose colored glasses. We're like, oh, nothing will happen. I just want to protect my interests. And you want to make sure that every portion of that contract protects your interests and discusses if something goes wrong, how are you protected? Because we really don't ever consider the bad. We always think about how good this relationship will be if we both fulfill our sides of the bargain. So I don't think that you should pull your NDAs off of Google, because I've had contracts where I've reviewed for clients, and they have subjected themselves to different jurisdictions, not realizing that, hey, I just got this contract off of Google. I live in Florida. It says that if we ever have a dispute, we're going to go to California. Neither party lives in California. So these are things, these are details that you don't even think to look at. So I never recommend that you do any contract, not just an NDA, any contract on your own. Go to Instagram. More questions on Instagram. How do we prepare a training manual for our business and create training processes? You just develop SOPs, and those SOPs become the secret sauce to your business. And then when you've developed those SOPs, you are putting yourself in a position where you can franchise it, because you're creating the blueprint on how to run your business. And if anyone deviates from that, then they would be in breach of that contract. So I always tell people, as you're developing SOPs in your business, consider a third party reviewing that and taking that and applying that to their own business. And hopefully it's the franchise. And if you've created SOPs and it's stolen, because that is a copyrightable material, if that SOP is stolen, then you can file suit for copyright infringement. You can also cover your SOPs under an NDA. So if anyone decides to take your SOPs and replicate them in their own business, they've effectively breached the disclosure agreement, because they have disclosed your operating procedures to that third party, which is the company that they own. So that's a great question. Yeah, there's a lot of things that we don't think of when it comes to law. I know that we love to go on Google. Listen, I will go on Google and try to self-diagnose any medical issue, right? But you should always consult with a professional, especially when it comes to legal, because there's a lot of money at stake. I highly recommend, if you are a business owner, and this is trademark related, if you're a business owner, please have insurance, because if you don't and you get sued for trademark infringement, or you want to sue someone for trademark infringement, especially if you get sued, you have that coverage. Your insurance provider can actually come in, hire attorneys to defend you. So that's a huge tip that I want to give you. Have insurance. If you don't, then you have to defend that lawsuit out of pocket. And most businesses don't have a reserve for litigation. We don't think that we're going to get sued ever. So have insurance, please. All right, we got about 5 more minutes before I log off, and we will do this again next month. Let me know in the comments what topics you want to hear, because I can talk about it all. We talk about trademarks, talk about copyrights. We can talk about leaving a legacy, so estate planning in business. Anything you want to talk about, I'm here. I see some folks joining. Okay, we have more questions. When looking for admin help, like a virtual assistant, do you recommend them having insurance as well? So your insurance should cover all employees. Make sure that when you are getting that policy, that it does cover all employees. If your VA is engaging in negligent practices, make sure that you have a contract with the company that hires them, because I have had VAs in the past, and I had a contract with the company that I was working with because I hired the company, and the VA was an employee of the company. So if there is any negligence, that company should have an insurance policy. So if you need to sue for the negligence of that VA, then you would file a claim with that company that you hired. That company, and I don't recommend that you go without a company. If you're just going on Upwork and hiring a VA and they're an independent contractor, then yes, you want to make sure that they have insurance. But if you're going through a company, then you want to make sure that they have insurance. So there's different ways around that, but I don't recommend hiring a VA as an independent contractor unless they have insurance coverage. Will this recording be available on your YouTube? Absolutely. So after we end this live, it will stay on YouTube. Okay, so we will be talking about leaving a legacy. So that includes succession planning, estate planning, which is trust, wills, powers of attorney, but specifically as it relates to your business. Because again, what happens if you leave this earth today? What happens to your business, right? You want to have measures in place to maintain that legacy. You want your brand to at least live beyond you. That's the goal, right? Awesome, awesome. Okay. Well, I thank you so much for joining me today. I'm going to give you guys 30 more seconds. If you don't have any additional questions, I'm going to log off. And I will send you all the links. If you sign up through Eventbrite, you will get a link of the recording. If you did not, shoot me an email. You can send me an email to info@stokeslegalcounsel.com. Let me see if I can do that here. Okay. So reach out to me if you have any burning questions. I will save those questions for the next live. I do plan to do this on a monthly basis, and hopefully we can grow as a community and do workshops, structured workshops on how to create passive income from your intellectual property. All right. Thanks again, guys, for joining me. Awesome. Thank you. Thank you, Griselle. All right, guys, have a wonderful Friday. Bye.